All right. Who do we have present from Pierce County Jail? Go ahead, counsel.
Good morning, Your Honor. This is Wallencheck.
Wallencheck. Did I pronounce that correctly?
Yes.
Okay. Mr. Wallencheck, 23L001431 and review 13L000025. And how are we proceeding today?
And Your Honor, with regard to the cause number ending in 1431, Mr. Wallencheck is prepared to enter a change of plea to that charge.
Okay. And any record you wanted to make, counsel?
Yes, Your Honor. I did have an opportunity to review this paperwork with Mr. Wallencheck. I've explained the elements of the charge as well as the rights that he is waiving by proceeding with this change of plea. I've also reviewed the recommendation for sentencing. I've explained that it is only a recommendation and the court is free to impose anything up to the maximum penalty. I've also reviewed the statement in paragraph 11. I did write that statement, but I have reviewed it with Mr. Wallencheck and he has adopted that statement as his own. I do feel he is proceeding with this change of plea knowingly, intelligently, and voluntarily, Your Honor, and I would ask the court to accept it.
All right, and just as, just to make sure that we're all on the same page, has there been a calculation of credit for time served? And is this a credit for time served recommendation?
It is, Your Honor. I believe there's 7 days, over a couple bookings, and I do have the dates if the court wants those.
Nope. If everybody's in agreement, I'm comfortable. It's just in many, many years of doing this, every once in a while, that's where we end up. And then sometimes people are disagreeing and then it hijacks what otherwise is an agreed recommendation. And I hate to get to that point and then have to back up or throw the plea away because the parties weren't on the same page. So it's just something I like to clarify before we head into it. So thank you. All right. And sir, I'm going to turn my attention to you. And I've already confirmed your name and your age is 40 years old and you completed high school and did some post-high school studying. Is that correct?
Correct.
And is it your desire today to plead guilty to one count of obstructing a law enforcement officer?
Yes, ma'am, it is.
Okay. And did you have an opportunity to review the guilty plea in its entirety with your attorney?
Yes, I have.
Great. And did she answer all your questions?
Yes, she did.
Do you have any questions of the court about what it means to plead guilty?
I don't. Thank you.
All right. And you understand that significant constitutional rights attached when you were arraigned, but by pleading guilty today, you give up all those rights except for your right to an attorney. Do you understand that?
Yes, ma'am.
You understand that there's a plea agreement. We discussed that a little bit, but that's an agreement between the parties, but I'm not bound to that. What that means is I don't have to follow it. I can impose anything up to the maximum if I decide that's appropriate in your case. You understand that?
Yes, ma'am, I do.
And did your attorney review with you the maximum penalty is 364 days in jail and a $5,000 fine?
Yes, she did.
And did she also review with you possible collateral or immigration consequences that could result from pleading guilty?
Yes, ma'am, she did.
Any questions for the court about those?
Nope.
I'm going to read you what's entitled the statement of facts. You let me know if this is your statement. On September 28th, 2023 in Lakewood, it says, I willfully hindered a law enforcement officer in the discharge of their duties when I continued riding my bike, knowing that officer was attempting to detain me. Is that your statement?
Yes, ma'am, it is.
How do you plead to one count of obstructing a law enforcement officer? Guilty or not guilty?
Guilty as charged.
Okay. Has anyone threatened you, pressured you, coerced you in any way into entering this plea?
No, ma'am, no one has.
Okay. And are you doing so of your own free will?
Yes, I am.
Okay. I'll accept the plea as knowingly, voluntarily, intelligently entered. I'll find there's an adequate factual basis to support the plea, and I'll find you've been advised of the nature of the charges and the consequence of the plea. I do find you guilty. Sir, you have a right to make a statement prior to your sentencing. You don't have to make a statement, but you have a right to do so. I'll hear from the attorneys and then I'll ask you if you have anything you want the court to consider as it regards your sentence, okay? So I'm gonna start with the city.
Your Honor, this is a plea and close recommendation where the city is asking the defendant to serve 7 days, which he has already served, just asking that he plead guilty to the charge, serve those 7 days, and he be released.
All right, thank you. Defense?
Thank you, Your Honor. We would ask the court to follow the recommendation in this matter. We do feel it is appropriate, given the underlying facts of this particular situation. I'm not sure if the court is aware, but Mr. Wallencheck was simply riding his bike without a helmet, which was for the basis for the stop. And then sort of made the unwise decision to keep riding his bike despite being stopped. So given the facts, we do let this is an appropriate resolution and ask the court to follow it.
All right, thank you. Sir, anything you want the court to know?
No, ma'am.
Okay. All right, well, I've reviewed the history and I understand the facts and circumstances. I think this is a fair and just resolution. I'm going to follow the recommendation. I will impose 7 days, suspend 0 and give you credit for 7 days served. And based on your appointment to the public defender and the circumstances as I see them, I am going to make a finding of indigency and also release you and close the case upon completion of the jail time. Nothing suspended or monitored. Any questions about what happened at your sentencing, sir?
No, ma'am.
Ask the parties to review the judgment and sentence, make sure it conforms to the court's ruling. And then turning to the order on revocation, was there intended to have any additional consequences?
Not from the city was not asking for any further consequences, Your Honor.
Defense?
Yes, we're in agreement. I thought our plan was basically credit for time served. I believe he was booked on all these matters, June 10th, so 3 days, credit for 3 days.
All right. And then as far as the review matters, that remaining open, or was the recommendation to close that one as well?
I would defer to the city on that.
Your Honor, the city was asking for those 2 matters to close as well.
All right. And for those to run consecutively? If it's 7 days or 3 and 4?
At this point, it's paperwork, so consecutive
Right.
is fine.
What I'll do, I'm gonna impose 7 on each of the matters, run them concurrently and close those files. So you will no longer have anything to address at the city of Lakewood at this point. And you'll be released on those matters. Any questions about what happened on the review matters, sir?
No, ma'am.
Ask the parties to review that, make sure it conforms to the ruling of the court, and then we'll sign those matters. I will order that you be given copies of those. Wish you good luck. And any questions as to what happened here today, sir?
Nope. Thank you.
And the city has signed the judgment and sentence, Your Honor.
All right. And I've signed those matters. I wish you good luck, sir. Take care. All right, this is Calico Sophia Soponsky, case number 23L000079, correct? Great. And how are we proceeding today?
Your Honor, I believe she's here for a review on a stipulated order of continuance. Parties have agreed, and I believe the only outstanding issue at this time is restitution. Ms. Soponsky did explain to me that for the last about 12 months, she was on disability.
I wasn't.
Oh, you
Trying
weren't
to
on
get
it.
on
We're
it.
trying to get on it, and you're on it now for a month.
Yeah, I got it last month, but you have to do a second part on the next month, which is apply for SSI.
Okay.
And so I'm still applying for that, so it gets active.
So she is finding her way towards being able to pay that restitution. Parties have agreed to set this matter out 120 days in order to give her the opportunity to get that done.
All right.
And Your Honor, let me see. I can't edit now, but she has agreed to extend time for trial in order to accommodate the 120 days.
All right, so I'm setting it to October 16th as the 120-day mark. Is that sufficient?
Yes, Your Honor.
And so I'll put it on the review calendar for October 16th, and then I'll add in that October 16th as the extension. And then there will be an additional 90 days past that. Is that the intention of the parties?
Yes.
Yes, thank you, Your Honor.
Just want to make sure that's clear since I'm adding it and not the attorneys. I've added the date of October 16th at 9 a.m. And I've added the extension of time for trial, a lack of objection from the city, a reminder to abide by any previously imposed conditions and otherwise granting the request to pay off the restitution and return to court at that time. Would you also like me to attach your contact information, counsel?
Yes, please. Yeah,
Or I'm just at Horwath Law, correct?
yes.
Great. I've added that to your order, ma'am. That way you have your next date, what you're supposed to do, and also your attorney's contact information all on that same form, okay? Any questions about what happened here today, ma'am?
Thank you. I apologize for not doing it within the set time frame originally.
I'm sorry, you're kind of soft spoken, so I can't quite hear you. Go ahead.
Where I'm not already paying it during the time given. So I didn't have income at the time and I was trying to find it.
She's
Okay.
just apologized for not getting it timely.
Understood. Okay. Well, appreciate that. And now we have a new deadline, and so we'll just look forward from here. And I am assuming that the agreement was to release her then.
Oh, yes.
Okay, all right. Yeah, we'll have to re-sign on that because I went through and addressed everything but that, which I'm fairly certain probably is the biggest concern of the defendant is whether she's having to stay in custody or not. So people have to re-sign, but other than that, you will be released today, ma'am. Okay? Wish you good luck.
Thank you, Your Honor.
The city has signed that, Your Honor.
Great, thank you. All right. Sign those, and I believe I've signed the several of the other motions to dismiss. And so is that all for Pierce County?
That's my understanding, Your Honor. Thank you.
All right. We will go off the record until Nisqually. Thank you. Good morning. Can you give us your full name slowly, please?
Good morning, my name is Colt Baldwin.
Okay. Colt Wesson Baldwin?
Oh, I apologize. Yes, ma'am, Colt Wesson Baldwin.
Oh, that's okay. I was just confirming. That's case number 22L001512, and we're on for SOC compliance. I'll let one of the attorneys start. Go ahead, counsel.
And Your Honor, I do note that we were looking for a victim panel and the defendant has yet to complete that. And he has 2 new criminal charges out of both Tacoma Municipal Court and Thurston County District Court with violation dates of March 20th, 2024 and December 24th, 2024, which I do not believe have been addressed on this case.
Okay, so 2 new convictions and an no,
They're still pending. They're not convictions.
I'm sorry, 2 new allegations. Thank you for the clarification. 2 new allegations and an outstanding victims impact panel. What's defense's request?
Thank you, Your Honor. Defense request, just to get right to the point, is for release on personal recognizance. Just confirm that we're still his attorney record on this case, Your Honor. So Corey Reardon for Mr. Baldwin. I did talk to him a little bit about kind of what's been going on with this case, Your Honor. And if you have a chance to look at the docket notes, you'll be able to see that he has filed proof of significant treatment. So he has done the Ingram management, proof has been filed. I believe he filed proof of the parenting courses at time of the SOC entry. I also wanted to highlight that this was a relatively long SOC. It's a 24-month SOC they entered in August of 2023. So there's still some time left on this 24-month agreement, in that the final SOC review hearing is not until, I believe, the very end of July, Your Honor. So the defense request is for him to be released on personal recognizance and to leave that final SOC review hearing set for July 31st at 9 o'clock. for a couple of important reasons. Mr. Baldwin, just wait one moment, please. Mr. Baldwin, those new allegations at this time are just allegations. Those are not convictions, as was clarified for the court. So what defense would prefer is for him to be given an opportunity to be released and see what happens with those cases before the city, before there's a decision on the city's motion, Your Honor. Further, I did talk to Mr. Baldwin about that remaining affirmative condition that shows on the docket notes is needing to be done. So he represented to me that he actually did complete the domestic violence victim impact panel. What he represented to me is that that agency that he completed the panel with, his understanding is that it had been sent to the court. I'm sure Your Honor has heard this before. I've certainly heard it before. It happens sometimes where something is completed, but there's no proof of it. So that's part of the reason for the ask of the release on personal recognizance, as well as the fact that those cases that are pending are not yet convictions or may never be convictions. Of course, I'm just asking the court to wait and see, leave that final SOC review date set, give Mr. Baldwin the opportunity to get out of custody and file proof of that victim panel right away. But that is the request, Your Honor. Also, Mr. Baldwin did want me to let the court know, and I think this is important information as well, as far as what he has going on the outside, Your Honor. He is the head of his household, and my understanding is that he very urgently needs to help his family be able to move out of that residence by the 17th, Your Honor, and further incarceration would definitely create great difficulties for him. But the main reason for the request, Your Honor, is all the reasons previously stated regarding the SOC, Your Honor. Thank you.
All right, so we've noted what the allegations are. There's been some very detailed explanations that it may have been accomplished. And I say may only because we don't have the proof of it. It's quite possible you did accomplish it, but hopefully you can understand from my perspective, it's also possible that you didn't, because unfortunately I've had people misrepresent to me before that they have done something that they haven't. So we just don't have the proof. I'll hear from the city. And if there's an objection to release and set to that July 31st for review and possible filing of the victims impact panel.
Your Honor, there's no objection to the city. There's no objection to setting it over to that July date. Frankly, if we were out of time on the stipulated order of continuance, the city would be moving for revocation today.
Okay. I'm just adding to your court order that you're to file proof of the victim impact panel at next hearing and address outstanding allegations of criminal law violations, just so that everyone knows what's going to happen at the next hearing. Hopefully, you will be able to obtain that proof and bring that to your next hearing. I will add your attorney's contact information to your order, so you'll have their contact. I'm going to release you today on your promise to appear at that court date and to attempt to address the outstanding obligations of the stipulated order of continuance. That will be on July 31st at 9 a.m. and that's a necessary appearance. Any questions about what happened here today, sir?
Actually, I was just wondering, so I've 100% completed that victims impact panel. Is there any way that you can give me a email address or something? Because the minute I get out of jail, I'm gonna go on to my emails and I'm gonna forward the
So on the court order that you're
completion
getting,
to you.
okay, on the court order that you're getting today, it has an email for your attorney who then can file it for you, okay?
Okay, cool. Thank you.
If for some reason when you're released, you don't get your paperwork or you lose it, you always can come by the Lakewood Municipal Court. We have all the contact information here. Just come by during office hours, okay?
All righty, thank y'all.
Any other questions for the court?
No, ma'am.
Any other comment from either party?
No, thank you.
All right, I'll sign that order. You'll be released today. Wish you good luck, sir. We'll see you at the end of July.
Thank you. Have a blessed day.
Good luck, sir.
Hello,
Hello there. What's your, can you give us your full name slowly?
Jimmy Guerrero Hernandez.
Gonna have to say it for me again, or counsel's gonna have to say it.
I could say, Your Honor, it's Mr. Jimmy Guerrero Hernandez. last name-
Hernandez. Okay, great. Thank you. All right. And that's your true and correct name, and is your date of birth June 6th of 1997?
Yes.
And you still reside or receive mail at the 3314 address in Tacoma?
Yeah.
Okay, and did you have an opportunity to review with an attorney the rights that attach at arraignment?
Yeah.
Constitutional rights? Did you have a discussion about that with an attorney?
Yeah.
Did you have any questions of the court about your constitutional rights?
No.
Okay, I'm gonna turn it over to counsel.
Thank you, Your Honor. I did have an opportunity to review this charge of theft in the third degree with Mr. Guerrero Hernandez, the elements of the alleged offense, the maximum penalty, any mandatory minimums that may apply, Your Honor, as well as all of his rights at arraignment that attach, Your Honor. I believe he understands all of that. At this time, I'd like to stipulate to probable cause for the purposes of the arraignment hearing and setting conditions on this case, Your Honor, only, and would like to enter plea of not guilty on behalf of Mr. Guerrero Hernandez. Thank you.
All right. I will. Oh, I'm sorry, did you address appointment?
I'm not sure that I did, Your Honor. Thank you. I do believe that he qualifies, and based on the screening, he qualifies without a promissory note, Your Honor. I'm asking for direct appointment. Thank you.
All right, so I will do a direct appointment to the public defender, so they will represent you on this case. I will allow a formal reading, waiver of formal reading and a not guilty plea on the theft in the third degree charge. And I'll allow stipulation today for purposes of setting conditions. At this point, sir, I'm going to turn it over to the prosecutor for the recommendation on conditions of release, and then I'll allow your attorney to respond, okay? Go ahead.
Your Honor, the city has no objection to the defendant's release on personal recognizance under the condition that he stay away from Safeway and have no criminal law violations during the pendency of this case.
All right, defense?
No objection, Your Honor. I do believe that's appropriate given the complete lack of history that I'm seeing on the DCH as well as the underlying circumstances of this alleged offense. Thank you, Your Honor.
All right, so sir, you will be released today on your promise to appear in court on July 15th at 1 p.m. out the Lakewood Municipal Court. You're also promising to have no criminal law violations, update your address if it changes, use your true and legal name and date of birth, and have no contact with the Safeways in Lakewood. You understand your conditions of release?
I understand.
On your paperwork will be the court date, your attorney's contact information, as well as all the conditions we just discussed. Do you have any questions for the court as to what happened here today at your arraignment?
No.
All right, anything further from either counsel?
No, Your Honor. Thanks.
Nothing from the city. Thank you.
All right, I'll order you be given a copy of this paperwork, sir. If for some reason you don't receive it or you lose it, you can come by the Lakewood Municipal Court to get the information that you need to contact your attorney and find out your court date, okay?
Okay. Thank you.
All right, I wish you good luck, sir. We'll see you in July.
Okay.
Good morning. What's your full name? Slowly and loudly, please.
Zachary Floyd Harmon.
Okay, Zachary Floyd Harmon. Cause numbers 25L004173 and 25L004037. One's on for pretrial, one's on for arraignment. And I'm going to go through the arraignment first just to confirm that that is your true and correct name as I said it.
Yeah.
And your date of birth is June 6th, 1985.
Yep.
And you can still reside or receive mail at the 917 address in Tacoma?
Yeah.
Okay, and do you have an opportunity to speak with the attorney in regards to the constitutional rights that attach at arraignment?
Okay.
Did you talk to your attorney about
Oh,
the
yeah.
Okay,
Yeah.
so do you have any questions for the court about your constitutional rights?
No.
Okay, all right, at this point, I'll turn it over to counsel.
Thank you, Your Honor. Corey Reardon. For Mr. Harmon, I did screen Mr. Harmon for appointment of the public defender. I do believe he qualifies without a promissory note, so I'm asking for direct appointment. As far as the arraignment hearing on the one count of theft in the third degree, I did review that with Mr. Harmon. As far as the allegations, any maximum penalty or mandatory minimums that would apply here, as well as all of his rights of arraignment. I believe he understands that all, Your Honor, and I would like to enter a plea of not guilty on behalf of Mr. Harmon. As far as probable cause, I will stipulate the PC for arraignment purposes only, Your Honor. Thank you. And also, I didn't mention this, I don't think, but I will waive a formal reading of the criminal complaint. Thank you.
All right. I will do a direct appointment as direct appointment to the public defender based on the record. I'll allow waiver of the formal reading on the theft in the third degree. And enter not guilty plea. There was previous appointment on the other charge, correct? On the other charges that are at pretrial?
That is correct, Your Honor, yes.
Okay, all right. And so at this point, sir, I've entered your not guilty plea waiver formal reading. I'll allow stipulation on the one new charge ending in 7-3 for purposes of setting conditions. And now I'm going to turn to the city for their recommendation on your conditions of release.
And Your Honor, the city is asking the defendant remain in custody until he can post $1,000 cash bail. This is a relatively low amount based on the defendant's criminal history, but the defendant has committed 2 charges of theft in the third degree in the spacing of less than 1 month, and both of these charges are located here in Lakewood. The further conditions the city would be asking for that the defendant stay away from famous footwear and have no criminal law violations during the pendency of this case.
All right, I'll hear from defense.
Thank you, Your Honor. I'm asking for release on personal recognizance with standard conditions for Mr. Harmon. He does live relatively close to the courthouse, Your Honor. He assured me that he can get to court by bus. So if Your Honor is willing to release him on personal recognizance, he's sure that he can make it to court. As far as that pending case, Your Honor, I do see that it's not like he missed court for anything like that for that case. There's a pretrial scheduled for June 24th, or at least it was until it was pulled up to track along with this matter, Your Honor. So my request today is for him to be released on personal recognizance. And if that docket is not already full, just have both of those cases track and be set to June 24th or any other date that the court would prefer if that date is not available. In looking at the court rule 3.2, Your Honor, and release of the accused, I do believe that here the presumption is for release. It's a non-capital case. As far as his bench warrant history, Your Honor, there is some. However, it appears to me to be pretty minimal overall. I'm looking at his DCH. There are a few cases that bench warrants have been issued, and then a couple of those are older, Your Honor. So overall, based on those factors, I don't believe he's an ongoing threat to the community based on this allegation as well as the previous allegation, and his warrant history again appears to me to be relatively minimal, Your Honor. So I'm asking for him to be given the benefit of the doubt and given a chance to appear out of custody on both pending matters, Your Honor. Thank you.
Thank you. Well, this concern of the court under 3.2 are some of the factors articulated by counsel, as well as the likelihood to appear, which it sounds like he lives close to the courthouse. I can consider prior failures to appear, which there are a few. And I do have concerns about an allegation when there was released not too long ago with the condition of law-abiding behavior. So I think at this point, the threshold has been met of concern of your ability to follow court orders. And so I don't think $1,000 cash or bail bond is an unreasonable request. So I will order that you're to post $1,000 cash or bail bond. I will set, counsel, do you have a request for the settings of these matters now that this June 24th will be stricken a week from today, or?
As soon as possible, Your Honor. If we could even set him as soon as the Monday in custody docket, Your Honor, that would be the defense preference.
Are we able to sit on the Monday? Well, I think 1 week is a very short time. I'm gonna set it to Wednesday. Normally I would set it a week out to Friday, but instead I'm gonna set it earlier than that to Wednesday for your next hearing, and then set you out of custody date if you post bail. Out of custody date will be July 8th at 1 p.m. I'll add that to your order. Give me just a moment. I've directly appointed the public defender. You'll receive that information on your court order, as well as the conditions of release as articulated by the city and stipulated by defense. No contact with famous footwear, as well as law-abiding behavior. Update your address. Use your true and legal name and date of birth. Any questions about what happened here today, sir?
No.
I'll sign that order. Anything further from either party?
Not at this time.
Okay, thank you. We'll see you next week. Thank you, sir. We'll see you next week.
So Mr. Harmon, you're free to go now. So we will see you next Wednesday on the in custody docket. If you bail out, you'll have court on July 8th, as Judge Barry indicated, okay? And you're free to get up now and they'll let you out of the room.
Good morning. Can you give us your full name slowly and loudly?
Right, well, Luckett.
All right. Draquel Travante Luckett, cause number 25L004177 on for arraignment. Is that your true and correct name, sir?
Yes, ma'am.
And your date of birth is July 16th of 1997, is that correct?
Yes, ma'am.
And you still reside or receive mail at the 1751 address in Tacoma?
Yes, ma'am.
Great. And did you have an opportunity to review the constitutional rights that attach at arraignment with an attorney?
Yes.
Did he answer all your questions about those constitutional rights?
Yes, ma'am.
Okay, any questions for the court?
No.
All right, I'll turn it over to counsel for entry of plea.
Thank you, Your Honor. First, I just wanted to address the fact that this is a conflict in that the co-defendant in this case, Ms. Sellers, was already arraigned this morning and has been appointed to Horwath Law Offices. So I
Okay,
did talk to him about handling this arraignment as a friend of the court, and I believe he's agreed to that if the court will allow me to proceed in that fashion, Your Honor.
all right. So you understand, Mr. Luckett, what he's talking about as far as a conflict, because he wants you to have your own separate attorney that has some kind of barrier between the information that the other defendant would share with their office and what you might share with your attorney, just so that all your rights are protected, okay? But for the purposes of arraignment, he'll help you through the arraignment process. And then from there on, if you qualify for appointment, you'll be appointed to another attorney so that you can make sure that that attorney is advocating for your sole interest. Does that make sense?
Yeah.
Okay. All right, go ahead, counsel.
Thank you, Your Honor. So I do believe that Mr. Luckett does qualify for court-appointed counsel, and I'm asking for conflict counsel to be appointed on this case, Your Honor. As a friend of the court, I did review the charge that was filed with him. I believe he understands the elements, maximum penalty, any mandatory minimums that would apply, as well as the elements of the alleged offense. We also went over his rights at arraignment, Your Honor. At this point in time, I'd like to enter a plea of not guilty on his behalf, Your Honor.
Okay, I will do a direct appointment to the conflict public defender. I've attached that information on the court order that you'll receive, sir. The other attorney's contact information. I will allow waiver of the formal reading of the one count of theft, a stipulation for probable cause for purposes of setting conditions, and a not guilty plea. I'm going to turn to the prosecutor, who's going to make a recommendation for your conditions of release, and then I'll have Mr. Reardon help you respond.
The city has no objection to the defendant's release on personal recognizance under the conditions that he stay away from Safeway and have no criminal law violations.
Okay, thank you. Defense?
No objection, Your Honor. Thank you.
All right. I will grant your release on your promise that you will appear at all your court dates, have no criminal law violations, and have no contact with Safeway, you said.
Yes, Your Honor.
All right, so do you understand those conditions of release, sir?
And that's every Safeway, or is that just that Safeway? The Safeway in general, right?
The Safeways in Lakewood. So there
Okay,
are
absolutely.
two Safeways in Lakewood though. So be mindful, okay, of, there's the one over on Stilcombe Boulevard and the one on Gravelly.
Absolutely.
Okay, all right, so I've set you for July 10th at 2 p.m. Oh, no, that's not a conflict date. Give me a second, I'm gonna pick the right date here. July, oh, it's highlighted, July 3rd, okay. I'm gonna set you for July 3rd at 2 p.m. Just a second, July 3rd, 2 p.m. All right, July 3rd, 2 p.m. will be your next court date, which will be on your court order. Your Mr. Rusnak, your attorney's contact information, as well as those conditions we discussed, will all be on your paperwork. And you'll be released. Any questions about what happened here today, sir?
No, not at all.
Anything further from either of the attorneys?
No, Your Honor, thank you.
No, Your Honor, thank you.
If for some reason you don't get your paperwork or you lose it, stop by Lakewood Municipal Court and they can tell you your court date and your attorney's contact information, okay?
Absolutely.
Okay, wish you good luck, sir. Take care.
Thank you.
Welcome. Good morning. Can you tell us your full name slowly and loudly?
Bo James Axlin.
Bo James Axlin, 25L004171 on for arraignment. And is your date of birth?
22881.
Perfect. And can you still receive mail or reside at the 15902 address?
Yes.
Did you have an opportunity to review the constitutional rights that attach at arraignment with an attorney?
Yes, ma'am.
And do you have any questions about your constitutional rights for the court?
No, ma'am.
Okay, I will turn it over to counsel.
Thank you, Your Honor. I did review all the rights at arraignment that attach with Mr. Axlin, as well as the charge, the elements, any maximum penalty and mandatory minimums that would apply here, Your Honor. I do believe he understands all of that. I'd like to enter a plea of not guilty on his behalf, and I will stipulate to probable cause for the purposes of this arraignment hearing only, as well as waive the formal reading of the criminal complaint. Thank you, Your Honor.
Thank you. Any record to be made in regards to appointment to the public defender?
Yes, Your Honor, I do believe he qualifies, so I'm asking for a direct appointment without a promissory note. Thank you, Your Honor.
Okay, based on the representations made, I will directly appoint to the public defender. I will allow a waiver of formal reading with a not guilty plea entered on the one count of theft in the 3rd degree and a stipulation of probable cause for purposes of setting conditions. I'll now hear from the prosecutor, the recommendation on your conditions of release, and I'll allow your attorney to respond.
Your Honor, the city has no objection to the defendant's release on personal recognizance under the conditions that he have no contact with Safeway, that he clear up his warrant out of King County District Court, and that he have no criminal law violations.
All right. Defense?
No objection to those conditions, Your Honor. Mr. Axlin was in an accident, I believe, relatively recently, so definitely would appreciate if the court would allow him to address this out of custody, Your Honor. Thank you.
All right. I will release you on your promise to appear at your next court date, which will be July 10th at 2 p.m.
Okay.
You're also to have no criminal law violations, update your address if it changes, only use your true and legal name and date of birth. Do not go on the property or have contact with the Lakewood Safeways, and also quash the warrant in King County District Court. Do you understand your conditions of release?
Ma'am.
Your court order will have your conditions of release that I just reviewed with you, your attorney's contact information, as well as your next court date. That's all on your court order that you should be given prior to release. If you lose it or you don't receive it, you can always stop by Lakewood Municipal Court to find out your next court date and how to contact your attorney. Any questions for the court?
No, ma'am.
Anything further from either counsel?
No, Your Honor. Thank you.
No, Your Honor, thank you.
All right. Wish you good luck, sir, and we'll see you in July.
Thank you.
Good morning. Can you please give us your full name slowly and loudly?
Nicholas Maderos.
Nicholas
Yes.
R. Maderos, 25L004175, for one count of theft in the third degree. Was that your true and correct name as I stated it, sir?
Yes.
And date of birth, October 17th of 1996?
66.
19, oh, it says 1996. I'm on the right one, right? It actually says 1996. Yeah, it's supposed to be 1966. I was going to say, I was going to be surprised that you were born in 1996. 1966 sounds a little more reasonable. All right. And then you have general delivery at Lakewood, correct?
No, I have a mail address in Tacoma.
Oh, you do? Did you want to give that to us in open court, or would you like to submit that at a later time?
I want to submit it later time because I think I know it, but I'm not exactly sure.
Okay, that's smart then. You don't want to get an inaccurate one on records. Okay, sounds good. And otherwise, I wanted to ask you, did you review with an attorney the constitutional rights that attach at arraignment?
Yes, I did.
And did you have any questions for the court about your constitutional rights?
No.
All right, I'll turn it over to counsel.
Thank you, Your Honor. As you just confirmed, we did review the right to arraignment that attached the charge, elements, maximum penalty, any mandatory minimums that would apply, Your Honor. Do believe he understands those things. At this time, I'd like to enter a plea of not guilty on his behalf. I will stipulate to probable cause for the purpose of this morning's arraignment hearing only, and waive a formal reading of the criminal complaint. I also do believe that he qualifies for appointment of the public defender's office, Your Honor, so I'm asking for direct appointment to Horwath Law without a promissory note. Thank you, Your Honor.
All right, I will allow a direct appointment to the public defender. So now you have an attorney formally attached to your case. I will allow waiver of formal reading of the one count of theft with an entry of a not guilty plea stipulation for purposes of setting conditions. At this time, sir, we'll hear from the city, their recommendation on your conditions of release, and then I will allow your attorney to respond. City?
City has no objection to the defendant's release on personal recognizance under the conditions that the defendant have no contact with Safeway and to have no criminal law violations.
All right, defense?
No objection, Your Honor. Thank you.
All right, sir, I'm going to release you today on your promise to appear at the next court date, July 10th at 1 o'clock at the Lakewood Municipal Court. Your other conditions will be to have law-abiding behavior, update your address, use your true and legal name and date of birth, and do not have any contact with the Safeways in Lakewood. Do you understand your conditions of release, sir?
Yes, you.
Any questions for the court about your conditions?
No.
All right, your court order will have that court date, your attorney's contact information, as well as all your conditions on it. If you don't receive it or you lose it, stop by Lakewood Municipal Court to get a copy, okay?
Okay.
All right, anything further from either counsel?
Thank you.
Thank you.
No, thank you.
All right, sir, I wish you good luck and we'll see you in July.
Thank you.
All right, can you give us your full name slowly and loudly?
Harley True.
Harley Sean True, 25L004180. Did I say your name correctly?
Yes.
Okay, and your date of birth is August 26th of 1974?
Correct.
And you still reside or receive mail at the Eatonville address 36708?
You.
Okay, and did you review the rights that attach an arraignment with an attorney?
Yes.
Any questions for the court about your constitutional rights?
No.
All right, I'll turn it over to counsel. One count of operating vehicle without ignition and airlock.
Thank you, Your Honor. I did screen Mr. True for appointment of the public defender. He does not qualify at this point in time based on screening, Your Honor, but I would like to handle this arraignment as the friend of the court with the court's permission.
Absolutely, go ahead.
Well, thank you, Your Honor. As a friend of the court, Mr. Reardon for Mr. True did review the elements of this offense, the maximum penalty, any mandatory minimums that would apply, as well as his rights at arraignment, Your Honor. We'll stipulate to probable cause for the purpose of this morning's arraignment hearing only, and I'd like to enter a plea of not guilty on the behalf of Mr. True, Your Honor. Thank you.
All right, I will permit the waiver of formal reading and enter a not guilty plea and a stipulation of probable cause for purposes of setting conditions. At this point, the prosecutor will make recommendations of conditions of release, and then you and the council will respond. City?
City has no objection to the defendant's release on personal recognizance under the conditions the defendant abide by ignition interlock requirements, defendant have not drive without valid license and insurance, and defendant have no criminal law violations.
All right, I'll hear from defense.
No objection, Your Honor. Thank you.
All right, those sound pretty reasonable. I will grant those requests. Sir, I will release you on your promise to appear at your next court date, which will be July 10th at 2 p.m. That will be at the Lakewood Municipal Court. You're to appear at that court date. You're also to have no criminal law violations. Update your address if it changes. Use your true and legal name and date of birth. Not drive with without a valid license and insurance, and to abide by the Department of Licensing rules regarding installation use of the ignition interlock device. Do you understand your conditions of release?
Yes.
All right. You will receive a court order that will have all those conditions as well as your next court date. And that will be a court date out in Lakewood. Any questions about what happened here today, sir?
No.
Anything further from either party?
No, Your Honor.
Thank you.
All right. I've signed that order. Wish you good luck, sir. We'll see you in July.
All right. Hello,
Good afternoon. Can you please state your full name slowly and loudly?
Patrick Philip McGee.
Patrick Philip McGee, 24L000763 on for review. And are you appointed to represent Mr. McGee, counsel?
Yes, Your Honor. I'm just pulling that up
Okay.
to verify, but I believe we are still on this case. Yes, Your Honor, we are.
All right. And this is on for review. See, it looks like you had some obligations, victim awareness education, MRT. And I don't show that those were completed. I'll hear from counsel.
Thank you, Your Honor. That information is correct. I've worked with Mr. McGee on this case, Your Honor. He does understand the treatment that he needs to complete. So I am asking the court to give him one more chance to comply with that. He has struggled a bit, Your Honor. I think it has a lot to do with circumstances that are a bit beyond his control, Your Honor, just based on his financial circumstances, as far as transportation being difficult. He did, my understanding is that he did go to a probation appointment and was late, but a bench warrant issued as a result, Your Honor. Worked to get a bench warrant quash hearing set, which I believe shows, good faith on his behalf to get a hearing set. Was not able to make that either, again, due to transportation. But I know that Mr. McGee has showed up previously. I've seen him in court out of custody, Your Honor. I am asking for him another chance. As far as the sanction, Mr. McGee, I believe, has been in custody for 2 days. So I would ask for the sanction not to exceed that amount of time that he's already served, Your Honor. There is still jurisdiction on this case, Your Honor. I believe that he entered the plea in November, and there's a 1-year jurisdiction. So there's quite a bit more jurisdiction on this case, Your Honor. Mr. McGee does, again, understand what he needs to do. He wants to comply with those conditions. So I would just ask for the court to impose a sanction no greater than the time that he's been in custody and to give him one more chance. I believe Mr. McGee understands that if he is given another opportunity to be released with credit for time served here, Your Honor, that he absolutely needs to get this done. And so he intends to do that and knows what he needs to improve on as far as timeliness to see it all the way through, Your Honor. Thank you.
All right, thank you. I'll hear from the city in regards to the 2-day sanction and reset of review hearing.
And Your Honor, I would note that he entered into the statement of defendant on plea of guilty back in November 1st of 2024, which gives the defendant practically 8 months to complete these conditions, and he has not yet completed the MRT or the victim awareness education. So the city would not be joining in defense's request. The city would be requesting a revocation period of 15 days based on the defendant's lack of compliance with the conditions of the sentence.
All right.
Thank you, Your Honor.
Anything further from defense?
Yes, Your Honor, something that I intended to mention earlier. So just briefly, Your Honor, to add an additional bit of context. I'm looking at Mr. McGee's defendant case history, Your Honor, and from what I can see, this appears to be his first conviction of an assaultive nature. I see only one other conviction on his record, Your Honor, so his defendant case history appears to have very minimal history here. These are conditions that are going to be ongoing, and so if he's able to be released from custody, he has served a sanction in being in custody for 2 days already. Again, this would give him the opportunity to acknowledge his failure to complete it to date, but understanding that he absolutely needs to get it done, Your Honor. So just ask the court to consider those factors as well. And again, ask for just credit for time served on the violation. Thank you.
All right, thank you. Okay, well, I do feel a sanction's appropriate. I understand both parties' perspectives in regards to the time that you've had to complete those obligations. That's been substantial time from the city's perspective. I also understand from defense's perspective that there may be some significant impediments to completing some of those obligations. And so I will find that you have not complied, as I don't think there's any argument to the lack of compliance. What I'm going to order is a 5-day sanction with credit for 2. And with good time, I don't know where that leaves you. The jail will have to tell you. And I will reset a review matter. I'm going to set that. All right, we are on the record on the in-custody calendar for Lakewood Municipal Court Nisqually calendar. And counsel, we're here with Marla Joy Renda, 25L000967. Is that correct?
That is correct, Your Honor.
Okay, go ahead.
Thank you, Your Honor. Corey Reardon for Marla Renda, Your Honor. As far as the history of this case, Ms. Renda was arraigned fairly recently on this case, just back in May, Your Honor. As far as the exact date, I believe that was on May 16th, Your Honor. And she was released on her own personal recognizance. I believe at that time she was set to a pretrial on June 5th. To her credit, I do believe as soon as she realized she had missed that date, she came to court to try to get it handled, but is now in custody, Your Honor. So I am asking for her to be released on personal recognizance one more time and be given the opportunity to appear on this case out of custody, Your Honor. Thank you.
All right, and I'll hear from the city.
City has no objection. City has no objection to the defendant's release to have her appear out of custody for her next pretrial hearing.
All right, and has council uploaded a document?
No, Your Honor, I can do that right now. I apologize. I'll upload a motion to continue, and I intend to request probably the July 10th date. If that date is still available for pretrial, Your Honor.
I think so.
No objection from the city.
All right, so we're gonna set your case, Ms. Renda, for July 10th at 2 p.m.
All right, Your Honor.
And all your existing conditions of release remain the same. I will attach your attorney's contact information on the order so you know how to contact them.
Okay.
And you'll be released today on your promise to appear at court and to abide by the conditions of release. Any questions for the court?
No, but I actually won't be released today. I was gone under supervision. I failed to report to my probation officer. I'm still gonna be kept here for Department of Corrections hearing. But I understand that as far as what we were dealing with this case, will be released when DOC is finished. I have no more to do with you guys, the rep for municipal court. Right?
Okay. All right, thank you. And so reach out to your attorney as soon as you're released. That's your best way to be able to follow through with whatever negotiations or resolution of your case. Your
All right.
attorney needs to have contact with you. Any questions, any other questions for the court?
No, Your Honor.
Anything further from either of the attorneys?
No, Your Honor.
Thank you.
Oh,
No, Your Honor, thank you.
I would ask if I have questions for that, sorry.
All right, I've signed the order, Ms. Renda. I'll order you be given a copy and you'll be released today. Take care.
Thank you.
All right, thank you.
Release America today, but not DOC. Thank you for it.
And Your Honor, city signed that order.
Thank you. And then there was one. Sorry, that's my lame reference to, I think it was an Agatha Christie novel. Because I'm old.
That's great. I usually catch most classics, literary references, but that one I'd have to go and read. So I appreciate it.
Well, I appreciate if anyone can follow literary references these days, right?
I know I've heard the turn of phrase before.
There you go.
I just didn't know where it was from.
It's just, well, and with Agatha Christie, it could have been from something else much older, but I'm a child of the 80s, so that was a big time for Agatha.
That's awesome. Yeah. For me, it's like, born in the 80s, but child of the 90s. So
You're right.
we were all the classics like Dickens and Salinger and all that stuff, but I guess those are
Right.
all old. Yeah.
Our calls case, people of Evergreen Apartment versus Kayla Smith. Hello,
Hello,
what's your name?
Kayla Smith.
All right, where are we on this?
Your Honor, Ms. Smith has brought her balance down to $516.41 inclusive of costs.
How much?
$516.41.
You go. No, I know. No.
And Your Honor, DHHS is paying the remainder, so
They're gonna be-
we need some
okay.
extra time for them to get that paid. I think a week should do it because they were supposed to submit payment on the.
Okay, my next available date is the 27th, so what I'll do is I'll adjourn it to June 27th, 2025 at 2 p.m. That's an in-person hearing, but if everything's paid, you're good.
So I don't have to come if everything's paid?
Don't
Fair.
look at it like that's a favor. You don't want to come see me? Is that?
I mean,
no,
I like to
that-
see
no,
you,
No, that's
but
okay. That's
childcare is hard.
no,
to
I'm
find.
hurt. My feelings are-
Okay,
I'll
26.
answer your question now. If everything's paid, you don't have to show.
Okay, good.
Okay,
Thank you.
just double check it. You may want to call.
Verify with Sydney.
Okay,
Sydney
okay,
will keep you updated.
okay.
All right, you have a great weekend.
Thanks, you too.
Flomar Apartments versus Caden Duford.
Jillian Engen, plaintiff.
You got him in all.
Yeah, he did check it. In person.
Caden Duford, can you check? Huh? Yeah.
And Your Honor, just so you know, we are requesting leave to amend. There was a 1 month notice to quit sent. And so
Got it.
requesting leave to amend.
No, when no answer. You're sure he was here? Yeah. And you're sure they were here?
Someone answered yes when I called Kate and Newford.
All right, let me pass it.
Thank you.
Glencoe Hills versus Tillman McCommons.
Jillian Aiken for plaintiff.
Also checked in. Great.
Hello. Hello, sir. Yeah. Your name?
Tillman McCommons?
All right, this is your motion to set aside the judgment?
Yes.
What's the basis for the motion to set aside, sir?
I was here last time. Finch, he gave me the wrong time for my appointment. Then he left and
Got it.
and went into default.
Okay. Did you? This was the one and
Yeah.
okay. So apparently there was a time that issue. He was here, but his time was wrong. So I'm gonna grant his motion to set aside.
I believe, Your Honor, that we have filed a writ, and so we can withdraw that.
Yes, and the writ's withdrawn. All right, and balance is what? this point.
I have a balance including court costs, Your Honor, let me just verify this, of $4,373.71.
All right. And sir, how are you intending on getting that paid?
Well, I can pay today. I got like 1,300.
All right, have you tried to work something out with the landlord regarding
I've been corresponding back and forth with her about that. And when I talked to her last time, she said my judgment was like 1660.
Well, your judgment was 2888.15. I set that judgment aside, but that was from May.
Okay, and then I came in to pay the motion. I paid like 1,200 for the
You
motion.
put 1,200 in?
Yes.
You certainly did, sir. He put $1,254 in. And you have how much today?
I like 1,200.
Gonna bring it down below 3,000.
Right. And are you working with Hawk at all?
I got denied.
Okay. All right, let's do this. I'm going to release the escrow to the plaintiff. Okay, so what you put in, I'm gonna order it released to your landlord.
Okay.
Okay, you have 1,200. I want you to pay the 1,200 today to the landlord also. Okay.
Okay.
And then what I'll do is I'll adjourn this out to June 27th, 2025 at
2 p.m.
2 p.m. to figure out how we're going to deal with the rest of the balance.
Okay.
Okay?
Yes, sir.
All right. Thank you, sir. Court does call the case of Glencoe Hills versus Devonta Jackson. And LaChina Williams. They did ask for what?
To appear soon, but I don't have either individual.
Devonta Jackson, LaChina Williams. Neither are here. Would you like to take it to phone?
No, I'm here.
Oh, you're here. Okay, your iPad. She usually has her name on. All right, go ahead. Okay, folks, I need to move this docket.
Sorry, Your Honor, Jillian Egan.
All right, this is LaChina Williams. She's here and didn't even credit me for getting her name right. No, I'm not going to say anything. Don't worry about it. Everybody's been hurting my feelings today. All right. How much do we have owing on that?
That's why I have a balance including court costs of $3,031.61. I have an update from my client that Hawk is that they are currently on a waiting list for funding. They're hoping they can make the request soon, and they will reach out when they have more funding and can submit the request.
Okay. But we don't have an idea as to when that's going to happen.
Right.
So are they thinking that it's even going to be before the end of the month, or?
I don't know. Sorry.
All right. Well,
Your Honor,
yes.
if maybe if the defendants could put some funds into escrow with the court, then it wouldn't necessarily if they can. I mean they're over $3,000 right now.
Right.
You can get that paid down and then any extra put.
Ms. Williams?
Yes, I plan to pay it down as much as I can, but I know I won't be able to pay the whole balance. That's why I was just going to wait on Hawk.
Okay.
Because I know July charges are going to come in effect as well soon.
Yes. So let me ask you this. If I ordered you to pay funds into court escrow, how much do you think you can pay?
I could pay $400.
Okay. So let's do this. Give it a chance to try to figure it out. Pay $400 to court escrow. All right, and that means you come down with cash to the court, put it in there. Okay,
Okay,
and so get that in, and then I'll adjourn this out to my next date, the 27th, 2025 at 2 p.m. And then we'll see exactly where we are. I may have to issue a judgment at that time, but at least we'll see, we'll know for sure where we are, okay?
okay, thank you.
Thank you.
Mhm.
Court calls the case of Hamilton Crossing 1 versus Victoria Bolton. Hello,
Hello,
what's your name?
Victoria Bolton.
Thank you. All right. And where are we on her case?
I have a balance including court costs of $2,237.
All right.
And I made a payment last week as well, and I plan on making one today.
Last week
You-
of $300.
Yeah.
Okay, I see that on the ledger.
Okay, was that taken into account?
Yes, Your Honor.
Okay. You said you plan on making another payment?
Yeah, but I feel comfortable putting in escrow right now.
Pardon?
I feel more comfortable putting it in escrow through the court versus giving it to them.
Why?
Because I just have a lot of pending work orders that's from like January. They don't really like repair anything. They told us if it's
All
not
right,
an
so how much are
emergency.
you gonna put into escrow?
Well, today I'm gonna do 300.
All right, you need to put $300 into escrow. You need to give a written list to the landlord of those repairs.
Mhm.
Okay, that you're saying that are going to be needed.
Okay.
And you're to do that by, you're to do that by this Wednesday, the 18th,
Okay.
with a copy of that list to the court.
Okay.
And then I'll adjourn this matter to June 27th, 2025, 2 p.m.
Okay. Thank you.
Thank you. Court calls the case of New Park Ridge Apartments versus Alana Armstead.
Jillian, can you complete
Hello,
Hello, Ms. Armstead. How are you?
I'm good, and yourself?
Good. All right, where are we on this case?
I have a balance including court costs of $1,575. Ms. Armstead and I did discuss briefly this matter. She's gonna make another payment of $300, is that correct?
Yeah.
And then she's getting assistance.
Through the Breeze program, through Michigan Works.
Through what?
The Breeze program, through Michigan Works,
Okay, so when are you gonna pay the 300?
today.
Today. All right, so you're gonna pay the 300 and then you're gonna get assistance that you think will take care of the whole thing?
Yes.
All right, so let me adjourn this out to June 27th, 2025 at 2 p.m. for you to, see if all that comes through.
All right, thank you.
All right, thank you. Let's call the case of New Park Ridge Apartments versus Precious Terman.
Jillian Hagan for plaintiff.
Yep. Somehow I knew Precious was in the house. Come on. Hello, what's your name?
Precious time.
All right, and what's the claim in this case?
I have a balance including court costs of $4,954.
All right, how are you intending on getting that?
Honestly, I feel like the whole process is a fluke because I'm low income and my rent is really only like $180 or something like that. And they're charging me market rent because they said that my recertification wasn't complete in a timely manner, which it was supposed to be done in January. I have been here 8 years and never have I had that completed in January due to the lack of them telling me what paperwork to turn in. I'll turn in a paper, they'll come back and tell me I need another paper.
Have you spoken to legal services at all?
I have not.
I'll give you an opportunity to speak to legal services since you're indicating that it's a,
Yeah, 500 of this balance is coming from them trying to charge me for my security deposit, which again, I've been there 8 years.
okay. I don't know that. I don't have a ledger in front of me.
I have one.
But what, okay, that's not gonna help me right now. So what I'm gonna do is I want you to at least reach out to legal services, they're actually present in the courtroom, and talk to them.
Okay.
I will adjourn this out to June 27th, 2025 at 2 p.m. All right, thank you. Court calls case People versus, or Faith Shepherd versus Lakrita Thompson.
Yes, can you hear me?
Yes, who are you?
I am Lakrita Thompson. I am
Oh.
the defendant. I guess you get them, the defendant. Yes.
The defendant. Okay,
Yeah.
I'll need a camera.
All right, here I come right now. Oh gosh. Oh, wait a minute. How do I do this? How do I do my
This is a
camera?
termination.
Yes,
Your Honor,
it's
this-
not. It's. Gosh, why did I get my camera on? This is weird.
Yeah.
This is a termination initiated by a notice to quit for a 1 month notice to quit for a month-to-month tenancy.
All
Okay,
right.
can you see me? Okay.
All right, Ms.
Okay, here I
Thompson?
go hold on right now. I'm doing it right now. Yeah, can you see me now?
I now can see you. All right.
Okay.
This is a termination of tenancy. You had a month-to-month tenancy?
No, I have a 2-year lease, Your Honor. I've been living here for 7 years. I also have managed properties for the owners. Right now, my lease is up in 4 months. I just got a notice. I don't have a problem if she wants to retrieve her property. I mean, her property here, her residence is fine with me. But I only have 4 months left with my lease.
So hold on.
I need time.
Hold on. So you're saying it's a month-to-month?
No,
Yes, Your
I have a
Honor.
2-year
And,
lease.
ma'am, stop. Plaintiff is saying that it's a month-to-month. You're claiming that there's a lease. I
Yes.
don't have a copy of the lease. Do you have a copy of the lease?
No, actually, I don't. I gave it to the owner's daughter 2 years ago. And I haven't had it, sweetheart. No, I haven't. So, I mean, Your Honor, I don't have it. She has it. So it's never been a month-to-month. As long as I've been living here, never been a month-to-month. I've been living here for
How
7
long
years.
have you been living there?
7 years. And I also manage properties for the owners. There are other properties that they have.
All
So I
right,
was
so
maintaining.
here's what I'm gonna
Yeah.
do, because that's certainly a dispute as to it. So I'm gonna set this for a non-jury trial, July 1, 2025 at 9 a.m. That's an in-person hearing, so you'll need to be here, ma'am. And they'll have to have somebody and show me either that there's no lease, or you'll have to show me that there's a lease, but then I'll make a decision on it, okay?
Okay. Also, I'm also leaking out legal help, legal representation.
All right, that's fine. You can have legal representation come with you on that date, but I'm gonna set it for trial on that date.
Thank you so very much. And you have a beautiful
you.
day. Thank you so much.
You do the same. What'd you say? Let's see who I want to call. Let me call this one. Strong Future Homes versus O'Day.
Jillian, you picked me good.
See, I'm gonna make you wait.
Good afternoon, Judge SImpson.
Good afternoon. What's your name?
I'm Lolita O'Day.
All right. And what's the claim in this case?
I have a balance including court costs of $909.67.
All right. So Day, how are you gonna get that paid?
I talked to Hawk and I'm waiting on my SER, but I was just at court, it's $800 and some dollars. Like, I don't know. This
It
is
looks
from
like
20,
it looks like a late fee might have been added.
this is from 2023, Your Honor.
Okay.
I mean, I don't know. They never told me nothing until now that I owed it this back money. And I just got
Okay,
to
do you
talking to
think you
legal
don't
aid.
know it? Or
I don't know. I can't remember what I ate in March of 2023, Your Honor.
what you ate in March of 20?
I don't know.
If you can even remember that far back. Because what was this morning? What did I have this morning? So yeah, that's as far back as I can go.
That's why I'm in court for 2023. I don't know. I just got my ledger from Tanisha. I got all my
Okay,
papers.
so
I don't
did you
know.
want somebody to help you go through that? Did you want to talk to legal services
Yes.
about going through that?
Yes, sir.
All right, so here's what I'll do. Let me adjourn it June 27th, 2025 at 2 p.m. That'd be an in-person hearing. Get with them, go through the ledger. Let's try to figure it out.
Okay, he said June
27th.
At what
That's at
time?
2 p.m.
2 p.m. Thank you, Judge SImpson.
You're welcome. Now you take care.
I'm at.
What did you say?
I will, thank you.
What did you say?
I said I will. I will take care of it.
Okay, you have a great weekend.
Yes.
All right. Did I make you nervous?
Still true. Yes.
Wow. Wow. Oh. You did not have to sign on to what she was saying.
When a person ain't never been through none of this, and, you know, I watch you a lot, and you're very, very, very fair, and I love that.
Thank
But
you.
I don't know, I'm just shaking.
No, I got you. Thank you for saying that. I appreciate that. Turn around and tell her that. Sparrowwood Apartments versus Regina Agnew.
Jillian Aiken for.
I was gonna make her wait to the end.
I thank you. God is good. I thank you because I want to go to work. I said, Lord, if you let me be out of here by 1:30, I don't have to call off because I need the money.
You are just gonna hold church up in here, aren't you? All right. What's your name?
Regina Agnew.
All right, thank you. All right, what is plaintiff's claim in this case?
I have a balance including court costs of $1,504.90.
All right, Miss Agnew, how are you intending to get it?
I talked to Robert G earlier, well, this morning about 10-ish, and I went on the portal because he straightened some things out for me where I can go in, and I paid $200.90, which came out to $206.91 because of 2.99%. That's a lot of extra money. $6 is a lot in this economy. But anywho, to make that payment, I had stated to him that on the 20th, I would make a payment again, and I will be all paid up by the 27th. Okay. So on next Friday, I will make a payment of $550 and the remainder on the 27th. Now, what I would like to say is, I understand business is business and they need their money. When I moved in the end of March, six days before the end of March, my door is, how would you say? I would say jimmied by the maintenance person, the sliding door, where if someone really wanted to get in my home, they could. And if I could just put it in escrow so they know that, okay, I know it's business, you bringing me to court. Yes, I owe you this. Yes, I do. But please make sure that my living quarters are good per the state guidelines as well, because they told me that it would take, the guy that came out and measured the door. You can. The gentleman that came out and measured the door said that they had been telling them Empire Management with the prior tenants that lived in that particular unit that I'm in now, that they would need to replace the door. And the door has not been replaced yet. And today is, you know what, June 13th, thank God I'm not superstitious. And it has not been replaced. So to be fair,
you need the door replaced.
I need that door replaced. I haven't been holding funds because of that. It's just other things that's been going on. And I just returned back to work on this past Tuesday due to.
What do you do for a living?
I'm in the auto industry, 26 years, auto industry. Yeah, I know they say, oh, why she in court? To all the,
no, I didn't.
Not you, Your Honor, but to all the, because you know, there's some people out here that watch this landlord-tenant stuff that don't work and they just want to, oh, such and such was in court because they owe for this, but it's real out here. And mental health is real. I have lost people, but I'm saying this for the viewers too.
Oh, so now you go ahead, girl. I you know what? I cannot stop you. Just go ahead. I figured she wasn't talking to me, so go ahead.
No, you good. You're right here. You're right here with me. You're right here with me. You just make me nervous. Well, I have to keep going back to the bathroom while I tell my neighbor. If they call my name, please tell them I just went to the restroom. But I haven't been holding money due to what they owe, but they're coming down hard on me. So since we're gonna be hard about it, please take care. You shouldn't even okay for me to move in when I did and things was not taken care of. That's all. That's all I'm saying. But I will have this satisfied by the 27th, and I look forward to seeing you. If I have to come back in here in court, I hope not, because my shift started at 2:30. And I don't have to call in because God is good, because I'll be out of here.
You know,
but we as people,
you just let me know when
you're
you're finished.
But we as people in the auto industry, we go through things too. I just want the viewers to know. You know, yes, I thank God for my employment. I was able to raise my children up on it, but there is things that goes on in life.
Okay, all right.
Thank you, Your Honor. I appreciate you.
And you. Did you want to say anything, Miss?
Your Honor, I don't know if I can follow that up. Is it the latch? It's just not latching?
It's what it is it's the sliding door, and so you know you have the door that latch, but the back side of it is a gap. Rodents can get in, so they put cardboard in there.
I see.
And they told me they ordered the door, it would take 6 weeks. So we're 6+ weeks out. And I just think communication's everything, like they tell me, and I agree.
Thank you.
But I'm not holding rent because of that. But since we in here, let's have a conversation about it. Respectfully.
Okay, did you want, you mentioned, I almost don't want to.
Escrow.
You want to put it in court escrow?
And I do.
All right, so you need.
Next Friday, I will come to the courthouse and I will put that $550 in, and the following Friday on the 27th, I will pay the remainder. And I tell you, Your Honor, you will not see me out of good faith in July, because July will be on time.
Thank you, ma'am.
You're welcome.
All right.
I appreciate you. I do.
June 27, 2025, 2 p.m. All right.
Okay, thank you.
You take care, and they'll make sure to
Have a
get
great
in your door. Really? Oh my God. I'm tired now. Northfield Estates versus Tamara Coppins.
Good afternoon, Your Honor. Rachel Dornbush, Pallets Law, on behalf of the plaintiff.
Hello, your name?
Tamara Coppins.
Tamara Coppins. I messed up the whole name, didn't I?
That's okay.
All right. What is plaintiff's claim today in this case?
Your Honor, let me
Oh, this is
verify.
actually her motion to set aside.
That's correct.
All right. And ma'am, what's your basis for setting aside the judgment?
I took a fall on their property and busted my kneecap in half. That was February 2nd, and I lost my job, a great job. I had just been approved. I worked for the Veterans Affairs, and I'm not quite sure I know what set aside means. I have tried to make payment arrangements with them. In fact, I even tried to make some payments, but I'm blocked to make them. And
let me stop you there.
Sure.
This is a motion to set aside the judgment which you filed.
Okay.
And in order to, I'm not even sure how it got set for a hearing because escrow was not paid or bond wasn't paid on this, but that notwithstanding, there are two things that you have to show me. You have to show me that you have a meritorious defense to their claim for rent. And then the other thing that you have to show me is you have to have some good cause for your failure to appear back on May 23rd of 2025.
yes, I can.
Okay, so why?
I went to the courthouse. And and it was closed in Saline. I'm on the summons, which I've never had before. It said peer to the court address above, and it said Zoom, but that box wasn't checked. I honestly thought that I would go to the courthouse, which I did do, and the judge would be on the screen. That's what I thought. But when I got there, it was shut down.
Yes.
And so then I panicked and I called, and the Northfield Estates told me, nope, you're evicted. And I'm like, what? And then I wrote a letter, and then the lady I was working with said, you got to fill this out. I filled that out. And I had no problem paying some money to an escrow. I didn't know about that. But basically, I've tried to make payment arrangements, but I feel strongly that they should work with me because this is on them. I mean, I didn't have to lose my job and fall. And so they should work with.
Ma'am, so let's assume I take that as a good cause. You're not disputing that you owe the amount.
I am disputing it in the sense that they should negotiate with me because I lost my job because of their
Negotiate
mistake.
In what sense?
Negotiate that I don't have to pay the rent or pay some of it until I get back to work. And then the whole thing, because I literally fell on their property and lost everything.
I understand that, ma'am, but I don't know anything about that as to whether or not it's their fault. I
understand what you're saying, but I've given them all my medical records. They know. That's why I was surprised when I got the summons. Actually, my mom got it, and I'm glad I saw it because she doesn't have a great memory.
Ma'am, I don't know whether it's because of anything that the landlord did that caused the fall. And that would not be before me.
Okay.
So the real question is how are you going to get this judgment paid?
I've offered them
Because there's probably more owing now.
Oh, I'm sure that there is.
And Your
How
Honor,
much is owing?
the total that's due at present, Your Honor, is $2,902.32. And Your Honor, if I could just state my position with respect to the motion itself.
Yes.
I don't believe that Ms. Copens has good cause for her failure to appear. She indicated that she went to the courthouse in Saline, which understand the courthouse is closed for renovations. But there's no indication that Ms. Copens then called the court to say, hey, I'm at the courthouse, it's closed, what do I do? Instead, she waited until later that afternoon to email me and say, hey, can we reschedule this? I had responded and said, unfortunately, no, judgment has already entered, so the court case is not going to be rescheduled. And so I don't believe that she's established good cause for her failure to appear. That's number one. Number two, I don't believe that Ms. Copens has established a meritorious defense to the underlying action. Your Honor, whether or not there was an incident on the property, and whether or not Ms. Copens can prove that my client was at fault for said incident, I am not conceding, Your Honor, in any way, shape, or form that they are. I would dispute any claims that they are. However, that is separate and distinct from any obligation that Ms. Copens has to pay rent, which she has not done. And so for those reasons, Your Honor, I would have to request that the court deny her motion and allow the judgment to stand in full force and effect. And at this point, we are well beyond the statutory 10 days that was entered on the original judgment, and would request permission for plaintiff to submit an order of eviction in this matter.
I would like to respond if possible.
Go ahead.
I'm not an attorney. I lost my cell phone service because I have no money. And I have to go hook up to a McDonald's or something, and I'm using these silly text apps. I got in touch with, I didn't know who to call because the place was closed. And then when I would hook up, I figured it out and I made my calls to the court. I don't know if I emailed them first. And I have had no problem. And I've repeatedly said, do we have to go to court? Can I pay this amount and catch up every month? So it is as if they want my dad's house. My dad was a vet, and it's like they just want it. So I don't even know what notarious means. I don't think there's any doubt in Northfield Estates, but it's not for this court possibly, or it's clearly not, but I don't think they have any doubt of where I fell and why I fell. But I don't even care. I just busted my knee, never been in sports, never had that pain except for babies. And I lost a
Okay.
job at the NFPA.
Okay.
So why can I not make a payment schedule, like $1,000?
Ma'am, that's gonna be something that has to be negotiated between the parties.
That's what I tried to do.
Okay, but if they don't agree to it, that means that you guys haven't come to an agreement on it.
Right, but they are now saying they want to evict me and my 83-year-old mom when the house has been in my family for 15, 20 years and it's been paid every month because I didn't prove that there was a good cause. I didn't go to court.
Ma'am,
I'm
you're asking
confused.
the court to do something the court can't do.
Which is what?
I can't force them to enter into a payment plan.
Okay.
All right. I am here right now on your motion and have to rule legally on your motion. And I told you at the very beginning, 2 things that you needed to show me: your good cause for your failure to appear, as well as a meritorious defense of the claim.
And both,
Frankly,
I've done one of those.
You have to show me both of those, and neither of those have you shown me.
I did.
We had gotten a call, and it sometimes does happen, and I'm not going to dispute that somebody goes to the wrong courthouse. We get a call, we get something.
You did.
That day.
You did.
Saying, ma'am, I don't have a record of that.
I sent it to the court, and you emailed me back.
Ma'am, don't overtalk me.
Sorry.
I'll let you go on. I'll let you tell me anything, but you're going to have to stop over talking.
Okay.
Even if you did, and even if I were to find that that's a reason for not appearing, I don't have a meritorious defense of the rent claim. I have to have both.
I don't have a lawyer. I wasn't told that, nor do I even know exactly what that means. So bottom line is they want $3,000, or what? How much does she want?
It would be $29,0218, but if you paid $22,3479, that may stop the eviction.
I'm very confused. I talked to this court. I spoke to this court. They emailed me back and said, Judge SImpson has set this aside. You're going to go the 13th. So you're telling me to show you something that
told you that.
I have my phone. I have your emails. I have it from your courthouse. Maybe not you directly.
I can.
She's been copied.
I've seen the email chain, and there may be some confusion. The 14A4 civil clerk did send an email on June 2nd stating Judge SImpson has granted your motion to set aside default. The motion hearing is set or scheduled for 6/13/25 at 1 p.m. This will take place in person at the 14A1 District Court and provided the address. Have a great day. Ms. Copens forwarded that email to my firm on June 2nd. I then reached out to the 14A4 clerk and I said, the tenant forwarded our office the below correspondence. I asked for clarification as to whether or not the motion had been granted or if the court had simply granted a hearing on the motion. The civil clerk indicated judge has reviewed the motion and set it for a hearing on 6/13/25 at 1 p.m. And I said, so the motion is granted, is not granted, just set for a hearing. If so, that may need to be clarified with the tenant because I believe that Ms. Copens was under the belief that the judgment had been set aside, not that a motion had been granted or a motion hearing had been granted. I did correspond with Ms. Copens after that and explained to her that no, per my communications with the civil clerk, a motion hearing had been granted only, not that the judgment had been set aside, and that the hearing that was scheduled for today would be before Your Honor to determine if the judgment should be set aside or if the judgment would stand. Ms. Copens responded something along the lines of, I don't understand, I don't know the legalese. I'm going to take it to mean the judgment was set aside.
Ms. Dornbush, were you reading, did they indicate initially that the judgment had been set aside?
The email to Ms. Copens does say the judge has granted your motion and set a motion hearing. So it's a little ambiguous, Your Honor. The document that I believe was provided to Ms. Copens, and I'm looking for the notice to appear, it doesn't indicate hearing for non-payment of rent, it indicates motion hearing. And I'm looking for
Yes.
the attachment.
I'm looking at it now, actually. I'm looking at our notice that would have gone out. All right. All right. So you're having the hearing at this point, ma'am. I have not ruled on it at this very moment. However, I'm telling you, I need two things. And the first thing being that there has to be a meritorious defense. Second thing being, and as I'll just tell you, neither one has been shown to me. So the motion to set aside the default is denied, the judgment will stand. And
So you're saying that they can evict me?
Ma'am, what I'm saying is,
I honestly don't understand.
okay, then I'll tell you this. The judgment that was entered on May 23rd will stand. And in that judgment, if you read the judgment, you have a certain time in which to pay those funds. As I indicated, that amount was $2,234.79.
Okay.
If that is not paid, then the landlord can seek their remedy, which would be an order of eviction, indicating that nothing has been paid on this, and then have you removed from the premises. Yes.
Okay, I have one more question. You were not going retrospective back that I had to pay it by the 23rd of that month. I can pay it today. Is that correct?
Do you have it today?
I can't, I will get it. I've got family and friends. I just wasn't gonna give
If
1,000.
you get it paid, they would need to, the way this court has ruled, they would need to accept it. So
Is there
if
an
it gets-
appeal? Because is there a way to appeal? And I'm saying that only because I was sent something
Ma'am,
that we're having.
Ma'am, I cannot give you legal advice. If you want to get legal advice on your rights,
I would like to do that.
then you can go and do that. But my order that your motion is denied stands. Motion denied. Thank you.
Well, I guess you're very welcome. All right.
This is the Butler County, Kansas first appearance docket of June 13, 2025. I'm David A. Ricke, District Judge. The first case I have on my list involves Jason Scott Hoffman. Is that the individual who's at the jail?
That'd be me, Your Honor, yes.
Okay. Mr. Hoffman, you were brought in on suspicion of possession of an opiate and possession of drug paraphernalia. However, the state is not filing on you today.
Okay.
I don't have any charges that I can read to you or hold you on at this point.
Okay.
I'm trying to discharge you from custody, but I need to ask you, where would you be residing should you be released from jail today?
I have my own apartment in Newton.
Okay, and what's the address there in Newton?
That's 733 West Haven. That would be one word, West, Westhaven.
Okay, and that's in Newton, Kansas.
It is in Newton, Kansas.
All right, the reason why I ask that is that the state, if they make a charging decision, very well may have a summons issued. It would have a date, time to appear in court. You'll need to make sure that if you get that at that address, that you appropriately respond to that summons once you receive it, okay?
Correct.
All right, Jason Scott Hoffman, I'm going to order you released on this hold at this time. It's not going to release you from any other holds that you might have on you from some other jurisdiction or case.
Okay.
But give them a little time and they'll get you processed out today. Just remember to come back to court if you get that summons or other paper.
All right. Thank you, Your Honor.
All right. There's nothing further than the Hoffman matter will be in recess.
I'm just trying to talk dog day or
Court will next call State of Kansas versus Antonio Xavier Jones. It's case number 2022 TR 1207. Jared Ricke appearing on behalf of the state of Kansas and the Butler County Attorney's Office. And I trust you are Antonio Jones?
Yes, sir.
All right, Mr. Jones, This is a pending traffic matter for driving while suspended. There
Yes,
looks
sir.
like 7 different docket entries for court dates that you were to have. I don't know why your case isn't resolved by now, but a lot of it, I think, has been complicated by your multiple failures to appear.
Yeah.
The last one was February the 24th in Judge Webster's court.
Yeah, I wasn't aware of that.
Okay, actually, your default on appearance took place even prior to that.
So I had multiple failures of appearances?
Yes, stemming all the way back to July 1 of 2024, from what I can tell.
Yeah, that's the one that I turned myself in July to take care of it. Then they gave me no, I didn't turn myself in July. I'm sorry. I turned myself in, I believe, in May 2024 for this suspended situation. And they gave me a court date in July. And I went there, but I went at the wrong time. And that's the only one that I know that I had a court date on that I was told. I don't know about any other failures to appear.
Well, you had a motion for judgment on bonds set. Obviously, you didn't appear for that. Judgment has been granted against you and Owens bail bonds in the amount of $2,500 due to your default on appearance obligations.
Mm-hmm.
We will need to get this set back before Judge Webster for further proceedings on the driving while suspended charge.
Mm-hmm.
I'm trying to see if you've ever had an attorney appointed.
No, I never had an attorney before.
Do you have the money to hire one now that you're in jail?
No.
Court will appoint Darren Patterson to represent you. And I will set a date on an expedited docket before Judge Lee on July 18, 2025, 1:30 p.m. You appear to be a very poor risk to let back out into the community pending court, Mr. Jones. So I'm going to leave the current order that's already been established, which is no bond hold order. So there's no bond. You're going to be held in jail until your court date on July 18th at 1:30.
Really? That's.
Well,
I'm sorry. I'm confused though.
Why are you confused? You had a court date.
Yeah. Can I explain myself, please? I gotta explain myself. I got pulled over in July, and not July. I got pulled over in 2022. Oh, I got pulled over. This one I'm aware of. I got pulled over in 2022 on driving on no suspended. I came back and I believe I got ODR'd out, but I never got a court date. And after that, I was just working, and then I called around to see if I had any warrants or anything throughout the courts in the district, and they told me I had a warrant here. So I came and turned myself in to take care of it, but I missed the court date. I don't want to disclose my medical information, but I've been having a gut imbalance since I was 18, and like it messed up my whole overall health, especially my mental health. And I went to my court date, but I went at the wrong time. I thought it was in the afternoon. But that's the only court date that I am aware of that I did fail up here. I don't know about any other failure to appears.
Well, you have failed to appear according to the docket notes at least twice, back in June of 2022, and again.
I wasn't aware of that. I would have
July of 2024. Again, the order's already been made. I just don't see any real reasonable grounds to change it, Mr. Jones. So at this point, you're on no bond hold status. Your court date is July 18th at 1:30, and I've appointed you a lawyer to represent you, Darren Patterson. So any other business from the state's perspective we need to address at this time? Mr. Ricke?
No, Your Honor.
Okay. Then at this time, the Antonio Jones matter will be in recess, and we'll move on to another case.
Dang.
Right. Sai Justin Jones?
Yes, sir.
Okay. Court calls State of Kansas versus Sai Justin Jones. It's case number 2025 CR 17. Sai Jones appearing at by jail Zoom. Jared Ricke yet appears as prosecution counsel. Mr. Jones, I see here that you had a court date on May 30th. Judge Ward was presiding as a pro tem judge at that time. You apparently failed to appear. That court ordered bond forfeiture bench warrant with a no bond hold. Makes me wonder why you didn't appear for court when you were supposed to, Mr. Jones.
My boss called about 5 days ago asking when my next court date was, and they said my next court date was the 20th, and then all of a sudden they picked me up. So there must have been a miscommunication somewhere. Because my boss, he's pretty adamant about taking me to my court dates for me.
Well, you were in court on January 17. At that time, a hearing was set for March 24th at 9 o'clock. Docket notes from that date say you just simply failed to appear in March.
I guess so. I mean, I didn't have any idea it was on that day. I mean, like I said, I try to keep calling in and checking in as regularly as I can to make sure I don't miss nothing. And they said next court date is the 20th, and then next thing I know, the sheriff's were picking me up. I guess just miscommunication or something.
Well, somehow you must have called, or someone on your behalf called and got another court date, an opportunity to surrender, essentially,
Well,
for
yeah,
May
must
30th.
have.
But Judge Ward's notes from May 30th, at least according to the docket sheet, you didn't appear for that. So Judge Ward issued a no bond hold order.
Right. I have no idea what happened, sir. I really don't. I would have been there if I would have known.
And Your Honor,
Mr. Ricke?
for the court's edification, I am showing an appearance bond in the file that appears to be 6,000 professional surety, and specifically refers to that May 30th, 2025, 1:30 p.m. date.
Try to locate that. Yeah, apparently he bonded out of Sedgwick County,
Yes.
Jones.
Yes, sir.
And right on the face of it, May 30, 2025 at 1:30 p.m. So that would have been a form that you signed.
Yes.
I would presuppose you received a copy of it, but yet you didn't appear on the date you said you would appear when you bonded out.
See, that's what I don't understand. My boss went through my paperwork. I went through my paperwork, and he called to check it. You know, he said, I think he might have missed a court date accidentally. And they said, no, his next court date is on this day.
And what day was it that you thought you had?
That was 4 days ago, I believe. That would have been no, it would have been in I've been in jail for a couple of days. That would have been last Friday, I believe.
All right. Did you appear last Friday?
That's what the day he called to find out what my court dates were. And
Well,
they
I thought
said,
you thought your court date was last Friday.
no, last Friday is when my boss called to find out.
Well, they're not even supposed to tell you if there's an active warrant. So I don't quite understand what happened here. All I know is you had a scheduled court date. You didn't appear for it. You've been taken into custody, and there's a current no bond hold order. And quite frankly, Mr. Jones, I can't see justification for changing that.
Oh, man.
You don't appear to be a good risk to reappear. I'm going to set your court date for July 18 at 1:30 for Judge Lee.
I mean, I promise I'll be there. I mean, I got work I'm missing, bills I'm falling behind on.
All right, Mr. Jones, you promised when you signed your bond.
I know. I know, sir. I very much know this. I'm so sorry that it got missed. I don't understand how it happened. I swear we went through all the paperwork and everything and was doing what we're supposed to be doing. I mean, like I said, my boss is very adamant about making me go to my court dates, and he called and everything. I don't understand how this all happened.
Well, I don't know about your boss, but why aren't you manage your own scheduling affairs?
Well, I am. I do. I make up sure check my own paperwork too, but he was going over to double check everything. And he thought that there was a court date. And I said, well, I thought there maybe was too. And maybe we just can't find that paperwork or something. I don't know what happened, but we called in to check just to make sure. And they said the next court date was going to be on the 20th.
Do you have the financial resources to hire your own lawyer at this point?
I do not, especially not if I'm in jail.
Court is going to appoint Darren Patterson to represent you at your July 18th hearing. July 18, 1:30, Judge Lee's court. The current order remains in effect. The current order is no bond hold. The court will continue to enforce that previously made order. Mr. Ricke, anything further we need to address on Sai Jones?
No, Your Honor.
Very well. Then the Sai Jones matter will be in recess. We'll move on to another matter. All right, Gary and Blendell.
Yes.
This is State of Kansas versus Darian Blaze Blendell. It's case number 2025 CR 245. Jared Ricke appears for the State of Kansas. Darian Blendell appears from the jail Zoom location. Apparently, you were picked up, Mr. Blendell, on an active warrant. Count 1 alleges aggravated indecent liberties with a child, an off-grid person felony. As a felony is charged, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be July 14, 2025 at 2:30 p.m. You must fully appear at that time in Judge Satterfield's court. July 14, 2:30 p.m. Mr. Blendell, do you have the financial resources to hire your own lawyer on this?
I do not.
Okay. Were you working previously to before being arrested?
No.
Okay. Court will make a finding of indigency in this case, and it's a very serious case, and the court will appoint a lawyer to represent the defendant. James Watts is appointed. Got our court date set. Judge Satterfield previously established bond at $25,000, cash or professional surety required, with the condition that you have no contact with minor children. Mr. Blendell, if you're able to make that bond. All
Yes.
right. With that all recited, Mr. Ricke, is there anything else from the state's perspective that we need to address?
Not at this time, Your Honor, assuming the Judge Satterfield's orders can include all standard conditions, including no contact with any victims or endorsed witnesses. In reviewing the information filed by my colleague, Ms. Pierce, the endorsed witnesses list does appear to be quite extensive.
Well, some of them are law enforcement. All right. The court will add an additional condition of bond, Mr. Blendell, that you not have any contact or communication with any of the witnesses who are endorsed on your information. There's a whole series of names there. You're not to have contact or communication with any of those without getting prior court permission. With that now stated, the Blendell matter is concluded for today, and we'll move on to another case.
That's it for the jail, Your Honor.
All right, thank you. Appreciate your cooperation and assistance this afternoon.
Have a nice day.
You too. This is State of Kansas versus Quentin Lawrence Height. It's case number 2025 TR 1215. Quentin Height appears apparently on his own Zoom. Jared Ricke appears on behalf of the State of Kansas and the Butler County Attorney's Office. For Height, court has an information before it which alleges in count 1 a charge of interference with law enforcement, a Class A non-person misdemeanor punishable by up to $2,500 fine and up to 1 year in the county jail or both. In count 2, failure to register a vehicle, an unclassified non-person misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine or both. What are your intentions regarding a plea here this afternoon, Mr. Height?
Good afternoon. I do not intend to plead.
Why is that, Mr. Height?
I have a few clerical things I'd like to clear up. Did you personally read the case filing for BU-2025-CR-000261 in its entirety?
No.
Do you believe that the filing document is true, complete, and correct?
I'm not sure why I'm answering your questions, Mr. Height. We're here on a first appearance on a criminal case.
I am trying to clear up to make sure that the charging documents are true and correct before proceeding.
I see nothing openly defective about the charging document.
Okay,
Well, let's move on. If you don't wish to enter a plea, the court will be entering a plea of not guilty on your behalf, Mr. Height. And we'll be establishing another court date.
Your Honor, that would not be my preference. I would like to have.
Well, I don't care if it's your preference or not.
Thank you. I would like to have a probable cause hearing before a plea.
You're not entitled to a probable cause hearing. This is a misdemeanor case rather than a felony case, and you're not in custody.
Okay, I have challenges that I would like to raise on the record formally for both the case filing and the field case report from the arresting officer.
Let me ask you, do you believe that you have the financial resources to hire a lawyer to represent you in this case?
I will not be hiring a lawyer. Thank you for asking.
So you're going to represent yourself in this case, is that
I
correct?
will be presenting myself. That is correct, yes.
You do understand that if you can't afford a lawyer, the court will consider appointing you one,
I do comprehend this. Thank you.
but you reject either retained or appointed counsel, and you're going to represent yourself in this case, correct?
I will be presenting
All right,
myself.
very well.
Thank you.
There was an appearance bond posted in this case. Apparently, it was a cash bond in the amount of $2,000. It secured the defendant's appearance. The court has approved that bond and will maintain Quentin Height under it pending further proceedings in this case, which I will set.
Before that, I would like to request your lawful determination that this court has jurisdiction over this matter, as I cannot proceed until the field case report and the case filing are both verified complaints and true and correct.
I don't know where you're getting all this. According to the state's charging document, I'll advise you, Mr. Height, that it did take place somewhere in Butler County, Kansas.
Okay, thank you for
The
that.
court does believe it has jurisdiction.
I do have a copy of a field case report and a case filing that I received from the Butler County Attorney's Office as well as the Butler County Sheriff's Office, and I have found inconsistencies in both of the documents that I'm trying to raise here formally with you that I cannot make a plea until they have been resolved.
All right. So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only under the matter that you have moved on my behalf. I have not entered a plea.
All right.
Additionally, I'd like to let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint and charges against me, I must move for dismissal immediately based on the plaintiff's failure to present all the required elements. That is in regards to the case filing. Judge, I would also like to ask, will you be reviewing the case filing and field case report in their entirety to ensure that my due process rights are not violated before the arraignment hearing begins?
Court's going to assign the case to this division. I'm going to set a court date for Monday, August 25.
And what is the purpose of that court date, may I ask?
For further proceedings in the case, Mr. Height. It'll
Okay.
be your first appearance with following today's date. I'm going to set
Would
the
you
hearing
repeat that again?
time at 3:00 p.m. You may
My
appear
apologies.
by Zoom.
Is there an
3
in-person?
o'clock Monday, August 25 for further proceedings in this case before this court.
Thank you. And may I ask, is there an option for an in-person appearance?
Not for that court appearance.
Okay.
We'll conduct the next appearance by Zoom.
Okay. Is there an opportunity to be in person for any proceedings?
Yes.
Okay. And
But-
which proceedings would those be?
But what we've established today is the next one will be by Zoom. Now,
Okay.
if you don't want to appear remotely, you can come to the Butler County Judicial Center and you can participate from that location. You'll be participating by Zoom, but you can participate from the Judicial Center. To make
Okay.
sure that you have the resources available to you to fully participate in the next hearing. So Monday, August 25, 3 o'clock. He's going to represent himself. And the court
And-
has approved and maintained him under his previously established bond of $2,000 cash.
May I also ask what
Okay,
judge
just a
and what
minute, I'm going to ask the prosecutor. Mr. Ricke, is there anything else that we need to address regarding Quentin Height at this time?
Not on this particular matter, Your Honor, although in per my duty of candor as an officer of the court, I would tell the court that there does appear to be another case involving this same defendant, where it would appear that an appearance bond has been executed for at the end of next month. I'm not sure, given the court's order today, if the court wishes to address that matter at this time for the purposes of the judicial economy.
No. If he has multiple cases, that's the implication of having multiple cases, that he may have multiple court dates.
Very good. Your
So
Honor.
let's go ahead and cite for Mr. Height, just in case he doesn't have it written down on his calendar somewhere. What is the next scheduled appearance in this other case?
Your Honor, the state's information is that in Butler County 25 TR 1215, there appears to be a bond, specifically a cash bond in the amount of $1,000 for an appearance date on July 30th, 2025 at 9 a.m.
All right. I'll advise the defendant that he does have a separate appearance requirement in a different case for July 30th at 9 o'clock a.m. I trust that would be in Zoom court with Judge Webster on that date, Mr. Ricke?
That would be the state's presumption, Your Honor.
Okay, and then of course you've still got your Zoom appearance requirement in this court on Monday, August 25 at 3 o'clock, Mr. Height. I think that concludes our business on
I have
the
one
case at this
further
time.
question. One further question, please. For this matter, the new hearing that you have just set, who is the judge and the court presiding?
The new one that I just said, you mean in this case that was before the court today?
Correct.
This judge is hearing the
Okay.
case. Okay.
Thank you for clarifying.
And if there's nothing further, the Quentin Height matter will be in recess at this time, and we'll move on to another matter.
Thank you for your time.